Hello, good afternoon, and welcome to the law. This is your legal light. It is your health law. I'm Samson Lardy Anyenini. There's a judgment pronounced by the High Court sentencing Sedina Atieno and her deputy. They were both in charge of MLock, the place where government dedicates money so people can access the money to grow their small businesses. She and her deputy have been convicted, and they are supposed to serve sentences 10 and 5. But she, during the trial, while she was on bail and her passport had been seized by the court, made an application asking the court to allow her the opportunity to travel abroad for medical attention. She got it, and she has since not been back. So the trial went on in her absence, and she has been convicted, sentenced to jail in her absence. What does that mean? We'll be right back to give you platinum legal education. You're welcome back. This is the law. It's your legal light. It is your health law. And this afternoon, as we have announced to you already, we shall give you the opportunity in due course to join us with your views on the matters that we are discussing. As you know, the High Court gave a judgment in the matter involving Sedina Tamaklo Atieno, former CEO of MLock, and Daniel Azim, former operations manager. She had 10 years and he got 5 years. The two were found to have stolen 3.19 million Ghana cedis while at MLock, and they willfully caused financial loss to the state to the tune of 1.97 million. They made unauthorized commitments resulting in financial obligations to the government to the tune of 61.74 million Ghana cedis. So 3.19 million, 1.97 million. So put that together, say you have about 5 million there. Then 61.74 million Ghana cedis. They were found guilty of causing financial loss to the state, money laundering, and stealing, causing loss to public property, conspiracy to steal, and stealing. The Deputy Attorney General said, in Ghana, we have various laws. You can choose to stay away, but so far as we have laws for which you can be extradited from other countries to Ghana, be rest assured that she will be brought down to face judgments. It is important for everyone to handle money with care and remember that one day they will be judged for their actions. Public officers, including myself, should ensure they adhere to the rules properly. So, what are the implications of this judgment, especially that the chief culprit is not in the country, bolted long ago? And in due course, I'll bring you the law 101. My guest is Daniel Krang. Daniel, thank you so very much for making time to join us on the law. Daniel, please unmute your mic. Okay, so we'll try and resolve whatever issue there is with Daniel's line, and then we will continue. Daniel Korang is partner at Dome Legal Consult. He's based in Siani, and he is authored a number of legal texts, particularly on criminal law. So we can safely say he's a prolific author of legal texts, written so many of them. We'll re-establish contact with him, and then you will hear what it means when we say there has been a trial in absentia. What does that mean? And when a sentence has been pronounced in the person's absence, what is the effect of it? Because the person is not around. The judge, at the end, that is Justice Efia Sewa Asare-Boche, who is Justice of the Court of Appeals. She was sitting as an additional High Court judge. When she was done with her judgment, said that the prosecution is directed, that is the state, is directed to undertake forfeiture proceedings against the assets of A1, that is Sedina Tamaklo Atieno, in particular, who received substantially all the money lost to the state. So, all the money lost to the state, the judge found, actually went to her. So, the state must take processes to recover the money. And the proper processes of forfeiture, they will look for her properties, if she has bank accounts sitting somewhere, if she has homes, she has land, property, whatever they are, the state will go after them and recover the money to the republic. And that is more important because many people will say that all we are really interested in is the money. But of course, once the money is retrieved, you expect that whoever it is that has committed the offenses will also suffer jail terms that will be a deterrent to others who may want to do the same. Now, let me attempt to do this for you. So, we've heard some very interesting stories about how the Sedina Christine Tamaklo Atieno, who has been at large during the trial, we've heard stories about how she took MLock money in millions and intended to invest in, a banking or microfinance institution and sent the money to the institution. And the institution now got back to find out how much interest MLock intended to take from the money. So that's an investment. And when she told them how much interest they wanted on the money, they told her that the interest was too much and they wouldn't make any profit if they were supposed to use that money and to trade at that interest. So they asked her, how do we get the money back to you? She said, bring it in fiscal cash. So they gathered the millions of money, put it in Ghana Must Go, and drove it in a van to Bachona, where she went and picked the money, fiscal cash. So that money didn't go back to MLock. We're told about purchases, vehicles that were to be purchased about 3 times the cost of the vehicles. And so many other rotting, stories to tell. All right, so these are the counts. Count 1, stealing. And she's supposed to have committed this stealing on the 28th of August, 2014. And the amounts involved that she stole was 500,000. 2, that's also stealing. on the 13th of April 2016, how much did he steal? 84,000 Ghana cedis. 3, stealing. On the 21st of April 2016, 73,500. Count 4, stealing. On the 1st of June 2016, 126,000 Ghana cedis. 5, conspiracy to steal and stealing. 16th of June 2016, 114,000 Ghana cedis. Count 6, stealing. 16th of June, that's same day, 2016, 114,000 Ghana cedis. Count 7, conspiracy to steal. 14th and 15th of July 2016, 228,000. That's how much he stole on that day. Count 8, stealing. On the 14th and 15th of July 2016, same amount, 228,000. Count 9, conspiracy to steal. 20th of July 2016, 204,000 Ghana cedis. Count 10, stealing. 20th of July 2016, 204,000. Count 11, conspiracy to steal. 29th of July 2016, 192,000 Ghana cedis. 12, stealing. Same day, 29th of July, 92,000. 13, conspiracy to steal. 25th of August 2016, 158,000. Count 14, stealing. 25th of August, 158,000. 15, that's count 15, stealing. 31st August 2016, 50,000 Ghana cedis. And it goes on and on and on and on. And there were a total of 78 charges. That's what we call 78 counts. Each count involves a specific conduct, and in this situation, mostly stealing. And so you have the cumulative amount of 3,019 Ghana cedis, 19,000 Ghana cedis. And then you have the financial loss in 1.97 million Ghana cedis. And the unauthorized commitment resulting in financial obligations to the government was to the tune of 61.74 million. That's a load of money, right? Daniel Cran's connection is still not the best, but he joins us on phone to give us some education. Thank you very much. So let's begin. When we say there is a trial in absentia, what does that mean?
Thank you very much, Samson. It's unfortunate the connection is not the best we can have. Now, when we say trial in absentia in criminal law, let's start this way. If you have committed a criminal offense who is being tried, is tried in his presence. That is a general proposition of the law. What it means is that from the time the person is arraigned before the court until he is either acquitted or convicted, the trial must take place in the presence of the person.
That is a mandatory requirement by the Constitution in Article 19.3, correct?
Yes. Article 19.3 of the Constitution provides that any criminal proceeding must take place in the presence of the accused person.
Great.
But that same provision makes two important exceptions. And the exceptions are that the trial can proceed when the person fails to attend the trial or fails to appear after he has had notice of the tendency of the trial against him. So that when a person is arraigned before the court and he decides to run away after he has been granted bail, that person has waived his right to be present at the trial. That is the first fundamental exception to the general principle. When the person runs away or absconds after he has had notice of the trial. Now, the second important exception to this rule is that when the accused person is such a way that it him continue the trial in his presence, and to remove him the proceedings or from the trial. What this means is that the court has the power to say that the accused person should be removed from the court so that the trial will go on in his absence. These are the two fundamental provisions or exceptions to the general rule that a person must be tried in his presence.
Right, Daniel. So, Daniel, let's hold on there. I'm coming back to you. I understand that your Zoom is getting better, so let's get back to the Zoom because this line is also doesn't appear to be the very best. So, Daniel just took us to Article 19.3 of the Constitution of the Republic of Ghana, which commands that if someone is accused of any criminal offense and the court is going to try them, the court must do so in their presence. So they must be present whilst the trial is going on. But the law makes exception, and he speaks about two exceptions where the trial can go on in the absence of the individual. We have statutes. We have what we call the Criminal and Other Offences Act, Act 29, and then we have what we call the Criminal and Other Offences Procedure Act, Act 30, 1960, which provides a situation where you may be absent, you may not be available physically in the court for the trial to go on, and yet the trial can go on. Two exceptions that he was explaining, but because the line was not the best, let's see how it goes on this on Zoom. Hello, Daniel.
Hi, Samson.
Excellent. This is good. Now, treat us to the two exceptions that you were explaining earlier to the rule, exceptions to the rule.
All right, thank you very much. Said earlier that fundamentally, the law requires that when a person is being tried for a criminal offense, that person must be present at the trial throughout.
Right.
It means that from the time the person is brought to the court or arraigned before the court, he must be present. Whether he will be granted bail or he will be remanded, he must be present on every subsequent, hearing date. Now, this is the general principle. And the importance of this is very clear. It's easy to know. When somebody is brought before the court on a criminal charge, he's been accused. And he must be given the opportunity to meet his accusers and defend himself, cross-examine his accusers' witnesses, and present his defense.
Because the fundamental principle is that the accused is innocent until proven guilty or until he or she has admitted his offense.
That is it.
Right.
And that requires that if the person is presumed to be innocent, it is the duty of the prosecution to adduce sufficient convincing evidence to prove the guilt of the accused person. And so his presence at the trial is very crucial, very important. But I did say that the Constitution makes two important exceptions under which the presence of the accused person may be dispensed with. And the first exception is that when the accused person has had knowledge of the trial and he decides that he will not appear before the court, it means he has waived that right to be present at the trial. And the law permits the trial to proceed in his absence. So that when the person is admitted to bail and he runs away, which is very common, the person is on bail, he runs away, or he absconds, the court would not wait for him. The court may decide that we are trying the accused person in his absence because he has had knowledge of the pendency of this case against him. That is the first one.
Right.
Now, the second exception is that when the accused person is in court, but his behavior in court, his attitude in the courtroom, his demeanor in the courtroom, his actions or inactions in the courtroom point to the fact that the trial cannot conveniently go on in his presence, the court has the power to order that he should be removed from the court for the trial to proceed in his absence. We call such situation a disruptive accused person in court. A disruptive accused person. It means that his conduct disrupts the smooth trial of the case, and the court has the power to order that he should be removed from the court. These are the two exceptions under the Constitution. I must add that there are two more exceptions under Act 30, that is the Criminal and Other Offences Procedure Act, Act 30, where a person is very sick and is unable to attend court by virtue of that sickness, and the court is of the view that trial in his absence would not cause any prejudice to the accused person.
Right.
If the court is of the view that the trial in the absence of the accused person would not pose any prejudice to him, the court has the power to proceed in his absence.
Yes, but...
And there is this other exception.
Go ahead.
There is this other exception under Act 30 where a person may, an accused person may plead guilty through his counsel or by a letter to the court.
That's right.
So that when the person is served with notice of the criminal summons, he can write to the court to say that I am guilty, but I am not coming to the court. Or the accused person can say that I have asked my lawyers to be in court and to tell the court that I am guilty. Now, when that happens, the court has the power to proceed in the absence of the accused person. So let us understand that the Constitution provides only two exceptions, but Act 30 adds two more exceptions, making them 4 in total.
Thank you. Now, we know, and you lawyers say all the time, that there is this cardinal principle of law, very fundamental. If you break it, everything else you have done cannot stand. That there is something called the rules of natural justice. And the rules of natural justice has 2 legs. That a person must not be a judge in their own cause, in your own matter. But the second leg says that a person must not be must not be condemned without a hearing. Meaning you must give them an opportunity to be heard before you can condemn them or pass a sentence or judgment on them. How do you marry this with the circumstance where the person is not around and yet the trial has gone on and there is judgment against them?
Thank you very much, Samson. Let me begin by saying that when a person is being alleged to have committed a criminal offense, the law adopts a coercive approach in dealing with the person. What it means is that you cannot decide how you should be treated as an accused person. The law has provided mechanism for treating you, and you must submit yourself to that mechanism. Now, when we say the rules of natural justice, it is a requirement of fairness to treat an accused person with fairness so that our conscience will not be scandalized by any injustice that may happen to the accused person. Now, the second leg of the natural justice principle says that no one should be condemned in his absence or unheard. Don't condemn a person without hearing him. Now, when the person is given ample opportunity to be heard, and the person says that I don't want to be heard, the criminal law and criminal justice would not, say that because the person has said he doesn't want to appear to be heard, the process should be halted or should be held in abeyance forever. No, it will not augur well for any, criminal justice system if you do that. So now what happens is that when the accused person has had notice of the trial and he decides to run away from the seat of justice, it means he has effectively waived that right. Let us understand that every human right that the Constitution confers on us is not absolute. It is subject to limitations. It is subject to exceptions. It must be exercised within the confines and the boundaries set by law. So anyone who has been given the opportunity to be heard has the right to either present himself to be heard or decide to waive that right by either running away or behaving in such a way that hearing him would make the whole process a mess, would make it not convenient. And so I want to say that trial in absentia does not violate any of the rules of natural justice if the accused person was put on notice and was given sufficient opportunity to be present at the trial, but the person decides not to be present. That does not violate the rules of natural justice. So it is only
now let's come home.
Yes, Samson, please come.
Let's come home. In the situation where, in this case, the trial was ongoing, Sedina Ateno was on bail, and then she sought permission to be allowed to travel for medical care. And she was given the opportunity to go. Her passport, I think, had been seized and it was given to her so she could go and take care of herself. Since then, she has not returned. You will say that is a fugitive from justice?
Samson, I think that when somebody is on trial like Sedinam, looking at the gravity and the seriousness of the offenses that were preferred against her, to allow her to travel outside Ghana for medical treatment during the pendency of the suit, to me, was not a proper exercise of discretion by the authorities. In any case, we have hospitals in Ghana that all of us attend. So if somebody is under trial for these serious economic offenses, and you allow the person to go outside the country, not under police supervision, or you did not hand the person over to external security for supervision, then you can clearly anticipate that she will not return. Because I am sure that when the case started, her guilt, seemed glaring to her. And so it was just a careful and a calculated strategy to run away from the seat of justice. And so I would say that she knew from the beginning that she was not going to return. And so for me, if you ask my view, I would say that the discretion to allow her to travel outside in the first place was not properly exercised.
Oh, but the person would have been sick. In this situation, the judge, and you know the judge involved here is very strict in the way she does her thing. So it would have taken, you remember that there were publications over and over about her seeking the opportunity and she being denied and so on and so forth. So the court would have considered whatever critical situation she was in then, right?
Yes, Samson, I think that that would mean to say that the court was under pressure, from probably the social media to have allowed her to go. But we cannot criticize the court or the authorities for allowing her to go. But my view personally is that looking at the gravity of the offenses, it was not proper that she was allowed to fly outside Ghana. Because it was anticipated by all reasonable Ghanaians that she would not return for the trial to go on in her absence.
That's an interesting point there. So now let's move on to this. Before we get to, I think we can deal with her bail matter, but let's now go to the fact that she has been convicted, she has been sentenced, she's not in Ghana. What does that mean? Is there any issue? On our Law 101, the Law 101, normally what we do to start the show, we call it the Law 101, Section 315, subsection 2 of the Criminal and Other Offences Procedure Act, 1960, Act 30, says a sentence of imprisonment shall commence on and include the whole of the day on which it is pronounced. This would mean that on the 16th of April, when the judge convicted her and sentenced her, despite her being absent, the sentence begins to run from that day. Is that correct?
Thank you very much, Samson. Before I answer, let me say that criminal law is a creature of statute. A criminal offense is a creature of statute. A criminal sentence or criminal punishment is a creature of statute. What it means is that in criminal law, nothing can be a crime unless that crime has been defined in a statute and the punishment is prescribed in that statute. The same way, a criminal punishment can never be imposed or meted out to anybody unless a statute makes provision for that. Now, the law that you just read is very clear. It says that a sentence of imprisonment, we must be careful here because there are many kinds of punishment in our criminal law. We have fines, we have probation, we have supervision, by the police and all that. Then we have imprisonment. Mm-hmm. The law that you just read relates only to imprisonment. It says that a sentence of imprisonment shall commence. In fact, let me say something that this is the law that regulates the effect of a sentence of imprisonment. It says that it takes effect or it commences on the day it is imposed. That day is included. If you want to calculate when it takes effect. So the meaning is that when the court imposes a sentence of imprisonment and it is 10 years, the 10 years begin to run on the day the court, not on the day the person enters the prison. The day the court pronounces it. I must also make it clear that in Ghana, it is the court that imposes criminal punishment, not the prison authorities. And so when the court has imposed a certain term of imprisonment, we should calculate it from the day the court imposed it, and not when the prison officers admitted the person into prison custody.
So the state says it is going to commence extradition proceedings. Well, first of all, it means the state must locate her where she is before the state can commence extradition proceedings and ask whichever country she is found to extradite her back to Ghana. Is it not the case, rather, does it not make practical sense that if she is found and Ghana goes to that particular country, say in the US, and says, bring her to Ghana, and she is brought to Ghana, the sentence should begin to run from the day she enters the prison room? Shouldn't that be the case?
Something, this issue is subject to multiple interpretations and views. But as far as criminal law and the administration of criminal justice is concerned, every view that one expresses must have a statutory backing or footing. The criminal law does not admit of any guesswork or personal opinion. Now, let me take you to Nigeria.
Mm-hmm.
When you read their Criminal Administration Act, the Administration of Criminal Justice Act of Nigeria, it makes clear provisions on trial in absentia. And it says that when the court is minded to try the person in absentia, the court can convict the person, but can only impose a sentence when the offender has been arrested or the offender has submitted himself to the court. So the proper thing and the proper practice elsewhere is that when a person is being tried in absentia, the court can only convict the person, but should not sentence him or her. Because under section 315 that you read, when you convict the person and sentence him or her, by law, the sentence begins to run. Let me say that the running or the starting of the sentence is by operation of law and not by administrative convenience. So that when the person has not been brought to Ghana, the sentence is automatically held in abeyance. That is not a correct view. There is something in criminal law we call suspended sentences. Mm-hmm. When we say suspended sentences, that is where the court imposes a sentence and suspends the operation or the enforcement of the sentence until a future date. That law is not in Ghana. It's not part of our law. Under Ghanaian law, a sentence can be suspended only when it is passed on a pregnant female. When the female is pregnant and the court has evidence that she is pregnant and the court sentences her, the law is that the judge must suspend the operation of the sentence of imprisonment on that pregnant woman. What is the effect of this? It means that until a sentence of imprisonment is suspended by an order of a court, it keeps running and it will run until it elapses, even in the absence of the accused person or of the offender. Are you
suggesting by this that if Sedina Christine Tamaklo Atenu is not found and extradited to Ghana until maybe after 10 years, the sentence would have elapsed and there will not be a sentence for her to serve? Or that if she is found 6 years after the sentence was passed, she will serve only 4 years? Is that what you're saying?
Samson, that is what Act 30 says. That is what Act 30 says. It says that the sentence commences on the day it was passed, not on the day the convict enters the four walls or four corners of the prison yard. And so this discussion must bring us to the realization of a weakness, a fundamental lacuna in our criminal law, which is that our courts must be permitted or empowered to suspend their sentences in situations like this so that the offender cannot escape justice. Anybody who suggests to me that the sentence of 10 years will be held in abeyance until she's arrested must provide a legal authority to back that argument. My authority for saying that the sentence has started running is the provision you read on your screen. And it is clear, very clear.
Can we know that the law is developed by case law? Can you point us to some case law that confirm this position? Don't we know, for example, that sentences, when they are passed, a person may have been in custody, and the sentence will be computed in recognition of the time the person has already spent in prison, in custody?
Yes, that is also a constitutional requirement that every pre-sentence, custody must be computed to be part of the punishment to be imposed on the person. But here is the case. This woman, Sedinam, was not in court and she was sentenced in her absence. Now, in the face of this clear provision of the law, 315, which says that her sentence, in fact, her sentence commences on the day it was imposed. Why would you think that it will rather commence on the day she arrives in Ghana? And what is your provision? What is your the law on that position? You see, that is why I said that this discussion must tell parliamentarians that our law is archaic, is outdated, has been overrun by events, and requires immediate reforms. So that when judges are empowered to suspend sentences, that sentence would have been suspended awaiting her arrival from wherever she is or her submission to the authorities. And you asked of authorities to as it were,
confirm,
buttress, to confirm my argument that no court in Ghana has the power to impose a sentence today and make an order that that sentence should take effect from yesterday or tomorrow. Now, those who are listening to me may read the case of Kwame Ewuya versus the Republic, 2018, 127, Ghana Monthly Journal, at page 240. Kwame Ewuya versus the Republic, 2018, 127, GMJ 240. There is also the case of Charles Ansa versus the Republic, 2017, 111, GMJ at page 193. These are Court of Appeal cases in which the court expressly stated that no judge in Ghana can pass a sentence and say that that sentence should take effect from either yesterday or any future date. What it means is that the sentence that was handed down or passed by the High Court on the former CEO of MLock has already started running. And I have heard people argue that the law applies to only judges, it guides only judges in how they should pass the sentence and does not apply to the administration or enforcement of the sentence. That would be wrong, because the prison authorities do not decide how the term of imprisonment runs. For them, they only receive the prisoner and they will ask. So when you look at their form, the prison authority, their form, they have the date of sentence and date of admission. Now, it cannot be correct to say that the sentence will run from the date of admission into prison unless there is a clear statutory provision to that effect. The sentence, according to section 315 of Act 30, starts running on the day it was imposed. Now, let me say this. The lawmakers probably did not envisage a situation of the kind that we have now, where a person tried in absentia, maybe sentenced in her absence, and so they didn't make any provision for that. But to me, by saying this, I am not claiming superior knowledge of the criminal law to anybody. I am only trying to highlight that our laws, particularly on sentencing, requires immediate reforms. I mean, how can you think about a country like Ghana? We have been independent for about 60 years now. We don't have a sentencing act. We don't have any statute on sentencing of criminals, criminal punishment. This is a serious matter that Parliament must take up, because criminal punishment cannot be imposed in vacuum. There must be some footing.
Okay, Daniel, so you grab some water. Let's get our audiences to join us with their questions about this. I'm sure many people are not excited to hear that if she is found and brought to Ghana, her sentence will not commence from the date she enters the prison room, but it's already running. And if it does happen that she's found 10 years after, then it means the sentence has elapsed. There's no prison terms for her to, as it were, serve. And the judge, when she was passing the sentence, has said that I have also noted that the Republic has done nothing to the knowledge of this court. The Republic has done nothing to take advantage of international cooperation to bring her to justice, since she, as it were, absconded. This is when she was passing the sentence on the two of them. And she says the sentence against the accused persons. You can call us now and ask your questions, very brief, and Daniel Korang will answer your questions. You can call us now. As always, our phone lines are activated, and you see the phone number on your screen. She says the sentence against the accused persons also takes cognizance of the quantum of funds lost, the deliberation and enterprise with which the offenses were committed, and the fact that this type of white-collar crime is, in the experience of this court, one too many. The court had come to a point where it had done a number of cases and has seen that there are many people in suits and using pen to steal. It says the court will therefore, to curtail crimes of this nature, hand down a deterrent sentence to deter would-be professional criminals from copying the actions of the accused. And then it passed the sentence. When she particularly gave that money to the microfinance company, and they couldn't agree on the interest, and the microfinance company issued a check to cover the money to her. She says, I don't want a check, bring me cash. And they carried the cash and brought it to Bachuna fuel filling station, and she went and took that money. In Ghana must go back. Hello, what's your name? Where are you calling from?
I'm Jima, calling from Tuna.
Hi, let's hear you.
Yeah, I'm Samson. I'm grateful for this program. I just want to make a I want to appreciate what Lawyer Cranton, yes, Lawyer Cran said. I think that without this in place, someone will take opportunity of the circumstance and run out of the country after feeling such huge amount and moving away. So I think that having a statute to back this is encouraging, and we shouldn't be thinking about other explanations or whatsoever for this particular thing. But it has to start from the day she committed the offense.
It has to start from the day she enters the prison.
No. It has to start from the once we don't have, in as much as we wanted to face justice, we also have to rely on the law as specified.
Yeah.
So
it has to start from the day the sentence is pronounced. But that is what he talks about, the disadvantages and the lacuna in the law. So we should make provision where it will start from the day the person is arrested and then put into the prison room.
Yes, please. So until then, this is what we have. So Parliament has to take this up seriously. So
thank you very much. Let's go to Ima, is it? You're calling us from Kaswa. What's your questioning to Daniel Cran or contribution?
Yes, Mr. Samson, thank you for giving me this audience. I am concerned about the permission given to her to go to or to go abroad for what? Treatment. Was it documented here by a doctor that she needed what? Further treatment abroad?
Definitely.
That's my first question.
Definitely.
And number two,
that will always be required by the court. Okay. Thank you for your questions. Well, Daniel Cran has made his view on that already. How about this aspect that when she was on bail, there was a surety, Alex Mold, and she absconded. She's gone. What would typically happen? Daniel?
All right. Thank you very much, Samson.
Yeah.
Under the law, the state has power to hold an accused person in custody awaiting his or her trial. Now, the essence of bail is for somebody to appear to the court and tell the court that I appreciate the power of the state to hold this person in custody. But now, relinquish custody to me, give custody to me, so that anytime you need the person to come to court, ask me, I will produce the person.
Just hold on for a second. Hold on for a second. Mausi, let's hear you quickly.
Okay. Hi, Mr. Samson.
Mausi, go ahead.
Yes. Isn't the state responsible to send her a letter to whichever state she is to be extradited to the country?
Isn't the state responsible for what?
Hello, can you hear me?
Isn't the state responsible for what?
To send her a letter to be extradited back to the country.
First of all, we must find out where she is.
Okay, so does it mean you guys are raising an issue without knowing her whereabouts?
Of course, her whereabouts is not known. That's why she was not in the court, and the state has not brought her to court.
Okay.
All right, thank you. Bye-bye. Yes, Daniel, so quickly on that one, our time is almost up.
So the sureties who came to court to sign the bail bond for her are liable to produce the offender, but they are liable only in property or in cash. You know, when somebody signs a bail bond and the person fails to come, you lose the property that you probably use as,
So previously, you, the surety, will also be arrested. But since Martin Kwebu went to the court to argue that this should not be the case, you will only be required to pay the bail sum, correct?
The bail sum. And now, because of the removal of the imprisonment, bail has become easy for those who have money. Let's look at the quantum of money involved in this case. It's a matter of paying off the bail sum and you are free. And so people should not think that this matter only is a legal matter, it's a political matter as well. Why? Because I do not understand why the offender was allowed to travel outside. For me personally, if you ask me, I will say I don't understand. She ought not to have been allowed.
All right.
Kolebu is there, and the big hospitals are there.
but there are clear situations where we know that people need treatment outside, and there are clear situations we know that. Don't we have those situations? All right.
Samson, I have practiced law for many years now. I have seen people who are bound in chains in hospitals and policemen standing by them. Why? Is it because they are not political figures? I mean, we should make sure that we give appearance of equality before the law.
All right,
so that nobody
Daniel
will think
Kurang,
that some people are being treated.
Daniel Kurang, thank you very much. His partner, Adom Legal Consult, he's based in the Siani, and he has been very helpful to the law platform. Thank you so very much. And he's giving us all of this education. He has written a lot of legal texts in respect of criminal law. He's written, I suppose, over a dozen now, correct?
Yes, they are more than 10 now.
They are more than 10. All right. Thank you very much once again. So this has been the law. It's your legal light. It is your help law. We hope we were able to give you some education. Have a good afternoon.